Good afternoon, everyone, and thanks for joining us. My name is Daniel Zand, and I'm an articling student at Darusha Law Firm, and I'll be the moderator of this session. The speakers today are Golan Yaran and Syed Kabir. They are lawyers here at Darusha Law Firm with more than 20 years of experience, and they both have experience practicing law in multiple jurisdictions. They are first going to cover a variety of topics focused on losing a loved one and managing the estate. Once they are finished with the topics, we will then proceed to answer any questions that you may have. If you have any questions, please make sure you write them down in the chat and I will make sure to read them to our speakers. The chat option should be somewhere on your screen and you can write your questions there and I'll present them to our speakers. Please note that this is a general information session and nothing mentioned in this session should be taken as legal advice. Golan, can you start us off by talking about the first topic, which is upon death, organ donation, and funeral arrangements?
Yes, good afternoon, Daniel and Syed and all the viewers. Thank you for joining us this afternoon. On the issue of the things that need to happen upon the death of a loved one, one of the first things that comes up is the organ donations and funeral arrangements that one may, or the family needs to make as soon as the death occur. So one of the things that we're looking for is to see whether the deceased have left any instructions regarding a donation. If the family is aware of a power of attorney that was left while he was alive and maybe have already communicated those wishes uh, to give organ donation, whether it's for therapeutic or research or any of that purposes. Sometimes the deceased have communicated that to those he cares about and maybe wanted them to follow up on his wishes. Other times it may be only mentioned in his will. Um, the hope is that one or the executor, the person who's going to be administrating the estate of the deceased, would have a document that will, or the instructions regarding the issue of organ donation well ahead of time, because as you all may know, donation is time sensitive. It has to be happening as soon as a person is about to pass or immediately thereafter. I think that the window of opportunity of utilizing one's organ is very, very limited, and therefore the importance of having those instructions available to the loved one, the family, the one that is going to be looking after the estate well before, or at least soon before a person dies. That goes in the same fashion with respect to funeral arrangements. Some people have made or prearranged the scenario, or maybe they have already purchased the plot or assigned the funeral home, the church, etc., that they may be wanting to have their funeral and the place to be buried or cremated. So all of these things are important instructions to be given to the person who's going to be administrating the estate. And it's better that the loved one and the family has those instructions ahead of time, because again, there's a window of opportunity as to when things going to happen, and the family would like to make the arrangement soon after the death occurred. So that's the importance of having these things in order ahead of time. Ty, do you have any other comments on these issues of organ donation and the arrangements?
Yeah, so basically, thank you everyone, first of all, for joining us this afternoon in this information session. So as Golan was saying that, it's very important to have the organ donations done in a timely manner, because it is a time sensitive matter, whether, the organs can be, used in a certain purpose or not. Now, after that is done, it is very important for the person to or the next of kin, if there is no will, to go to the funeral home and then talk to them about your different types of arrangements, unless there is an earlier arrangement that was made by the person who died. Now, in terms of expenses or costs of the funeral home or for the burial, there are different types of packages that they have. So that can be different type of caskets they have. It can be cremation, it can be burial. It depends on the religion of the person who died. You know, it can, if he's a Muslim, it can be, he will probably be buried. If he's a Christian, he can decide whether he wants to be buried or he wants to be cremated. So different types of, you know, arrangements are there. Roughly, I mean, in my estimation or in my practice, what I see is that it would be at least $10,000 if we talk about, you know, those type of funeral expenses. So one of the things that needs to be ascertained, actually, as Golan was saying, that, you know, whether the person had died making a will, and if there was a will, what were his wishes in terms of, you know, where his body will go, or, you know, how he wants to be cremated or buried, or any of those wishes. So yeah, those were something that I wanted to mention as well.
Syed, you kind of touched upon the second topic now, but can you talk about funerals, religious rites, burials, and cremation, and some general comments about cost?
Yeah, so as I was saying that, you know, after a person dies, it is very important for the next of kin or the partner to locate a will, if you know, it is possible, as early as possible. If not, then that person should go to the funeral home, look at the different packages available, if it is not pre-arranged, and then look at the different costs, and then they have to decide, you know, what type of funeral would be best in the situation. And in terms of cost, as I was saying, in my practice, I've seen that, you know, I've seen funeral cost, you know, it can range from the lowest, I think, probably 7,500, around that figure. And I have seen even, you know, if they want to really, you know, a gathering of people, you know, coming and, you know, talking about the person who died, memorizing about him, can go up to 25,000. So it depends on the person's wishes, as well as, you know, the next of kin who decides, you know, how this is going to be, you know, done. So yes, that is what I wanted to add.
If I may add to that topic, Syed, I was thinking that um, the loved one, once they have an idea where the deceased wanted to be buried or whether he wanted to be cremated, etc., that I think that is an easy situation when one can simply follow instructions. The more challenging situations they may become where there is no definite plan, or the deceased have not has not given the instructions, or did not talk about his burial arrangement ahead of time with anybody in the family, and then you have different views coming from the next of kin that may be challenged by others, and so on. I think one of the important things is, like you said, Syed, is locating the documents. If somebody is aware that the deceased was seeing a lawyer in his recent years, or recent times, then he should be attempting to contact that lawyer and figure out maybe there is a will in place or in a safe, awaiting that instructions to retrieve the document. Other situation that may be of assistance is that if there is a dispute amongst the children or the family members as to the arrangement that should take place with regard to the funeral arrangement, uh, it may be that a lawyer would be in a position to assist, to mediate between the parties, and try to resolve that issue within a short period of time. Because I think most of us in any religion require the funeral to take place soon after the death of the person. We don't want to leave the body sitting in a cold room for a long time. I'm sure that everybody is eager, or at least are looking forward to that closure of a person who have just passed away, and arranging a respectful funeral or a ceremony, as the case may be, for that person. So that's just a comment that I thought that looking for assistance from professionals to resolve disputes that may arise is also something that one can give it some thought if that comes up.
Golan, can you talk to us about who takes charge in a situation where there is a will and also a situation where there is no will?
Yes, Daniel. So the idea is that one wants to follow a person's instructions if one was given in a proper fashion, and definitely if it is in a binding format, assuming a will was made and it's all in order. Um, One of the topics that would be covered in the will would be the appointment of the person who's going to be in charge. We refer to that person as the administrator or the executor of the estate. And assuming that one has the document and the appointment is clearly set out without any difficulties to ascertain who that person is, then that person has the authority to be acting on behalf of the deceased. Sometimes the situation requires that the court would actually make that certification, what we call as probate, to appoint the person, and that calls a process by which one gets a certificate of appointment when there is a will. The same process may take place when there is no will. That means that when there is no will, one has to look into the legislation and the priorities that are given in terms of who can apply to become the administrator, the person who's going to be looking after the estate. For that purpose, again, if there is a dispute and there is no agreement, then a certificate of appointment for a state trustee without a will is the process by which one need to proceed and obtain that certification from the court to move on and have the formal position of an estate trustee. So in terms of a obviously having a will would be the preferred approach because the deceased is actually able to ascertain or at least decide the person whom we trust that can be responsible and will follow his instructions as and wishes as he dictates in that document. The situation becomes more muddy once there is no will and there are multiple people who may come forward and would challenge the position of the one claiming to be the next of kin. It may be between common law spouse and a legal spouse. It may be between the siblings. There could be all sort of scenarios that may arise when you leave things in a limbo and you don't point out ahead of time who the person that you wish take charge of the estate upon death. Said?
Yeah, so just to add to what Golan was saying, as Golan was mentioning, because if there is a will and there is a state trustee or an executor named in that will, that person would apply to the court to probate the will, and then you get a document which is called the certificate of appointment of a state trustee. But we have also seen that where there is circumstances where the will is challenged, or the other beneficiaries who are people who are entitled to receive a share in the assets can challenge that document, and then the court needs to determine actually who will be the estate trustee. So in terms of situations where there is no will made by the person who passed away, in that case, the law actually takes the precedence, which is the Estates Act in Ontario. So basically, the law says that the person who's applying must be a resident in Ontario, and the person who, there is also a list of people who are actually given priorities in terms of who can apply. So the first person who can apply is actually a married spouse or conjugal partner who is living with the deceased at the immediately before the death. There can be children of the deceased, there can be grandchildren. There are also situations where a person doesn't want to be an estate trustee. They might say, you know what, I am so upset about this entire situation. I'm in a bereavement. I cannot take this because it's a lot of responsibilities involved. So of course, along with the guidance of a lawyer or a professional, you need to have that, temperament and that, um, in that physical and mental situation to manage the entire state of that person. So if a person does not want to be an estate trustee, then they can also renounce that by way of an application to the court. So one of the things that needs to be understood that if there is more than say $20,000 in the bank, or if there is property involved like a house or anything, in both situations where there is a will or without a will, an application needs to be made to the court so that the court actually grants a certificate by which the person who is applying can manage the assets of the deceased. Daniel?
Syed, can you talk to us now about some of the duties and obligations of executors and administrators of the estate, and any professional assistance that they may seek?
Yes, thank you, Daniel. So this is a very, very crucial and important question. An estate trustee is in a trusted position. So a person who is named in the will, or if not named in a will, or if there is no will, the wife or the conjugal partner who was living with the person before his death, or the children, they have to act in a trusted position, and they first have to locate the will. If there is no will, they can find. They have to arrange for the burial of the person. They have to ensure that the property or the assets that the deceased have left are taken care of. They have to contact the insurance company. They have to ensure that all the authorities, the Service Ontario, Service Canada, these authorities are informed about the death. If there is a safety deposit box, they need to ascertain what is in the safety deposit box. They need to go to the bank. They need to make all sorts of inquiries with different authorities, institutions. And so what we usually do is we provide a checklist to our clients, so that the clients can have that checklist, so that they know what they have to do. And then a lot of people become overwhelmed. So that's why we actually as lawyers help them out in drafting letters, or assisting them in what to do and where to write letters, and how to manage the entire state as the time goes by. And then we help them throughout the process, starting from the probate. So as I said, an estate trustee's first obligation is to understand what the assets are, because based on that assets, you have to pay the estate administration tax. So once that is done, you can apply to the court through a lawyer, and then, or you do it yourself as well. But it's very difficult to for a person in that situation to make an application exactly properly. So and there are many very minute details, and we have experienced that even if there is a small errors in the application, the state court actually returns the applications back. So it has to be minutely and detailed work is needed for the application to be filed. You need the proof of death certificate. So all these things together, you file the application, and then the court actually grants the certificate of appointment of a state trustee, and then that person has to manage the state. And after part of management is, of course, the distribution of the assets of the state based on his or her wishes. And at the end of the duties, you have to also file a terminal tax return with the Canada Revenue Agency, because that is also an obligation of the state trustee, that whatever the deceased had on the income on the date of death up to that time, a final tax return has to be submitted. So yeah, a lot of obligations involved. So Golan, if you want to add something more to that.
Yes, thank you, Syed. I was just thinking, of course, as Syed mentioned, it could be an onerous duties on the person who takes on the role. So the idea is that one cannot take that very lightly. There is a set of expectations and liabilities that lies with that person who takes on the task. But that does not mean that a trustee should be doing everything on his own. He's obviously free to get assistance from professionals, including accountants, including lawyers, including other people that may need to appraise the property or other things that may be involved in the administration and decision relating to even something, for example, selling the contents of a deceased by way of an auction. You can hire an auctioneer. Everything has to be done in such a way that would be discharging your duty as a state trustee in a professional and by doing your due diligence that way. So by hiring professionals is certainly discharging a lot of these duties and making sure that they're actually being done in a fair and balanced way. Uh, One of the major expectation from the state trustee is to keep the records and be able to pass accounts in due course. So everybody is aware of all the assets that were collected and what happened to them in the course of the administration of the estate, how assets were disposed of and distributed, and how much money is in the various bank accounts, in whether accounting was done and taxes were paid, and all of the things that you want to discharge your liabilities, whether it's to Revenue Canada or to the beneficiaries, because at the end of the day, you want to be able to have the beneficiaries say that they are happy with a performance in such a way that they don't have any further claims from the estate trustee. You don't want to have lingering liabilities and duties past the administration of the estate in the shortest way possible, in the shortest period that is possible for you to do so. That is, generally speaking, the duties of a state trustee, that you can also use others to help you out in the course of doing that.
I would just want to add to what Golan was saying, is that, sometimes the state trustees I see in a number of situations, it's difficult for them to understand what forms part of the state and what does not form part of the state. So as we actually discussed in our previous information session, that, a lot of properties, if it is jointly owned or if there is a designated beneficiary, that would not be part of the state. So there also, it is very important to seek professional advice, and then, professional opinion can be sought as to what will form the state. Because at the end of the day, if the proper tax is not paid, then because after a probate is done, within 180 days, a state information return is supposed to be filed with the Minister of Finance. That is a legal obligation. So if the proper tax is not paid, then you can pay the remaining amount, or if there's a payment overpaid, then you can get it back from the Minister of Finance. So it is very important to have the calculation as to what is the value. So that's why Golan was mentioning that, appraisal and, all those amounts is important, so all these require professional assistance. That's what, I have seen in my experience.
Thanks, Syed. Golan, can you talk to us now about compensation or payment for those who take on the responsibility of being the executor or the administrator?
Yes, Daniel, thank you for that opportunity. What normally comes up as part of the process of the distribution and administration of an estate, there could be a quite significant time and expenses that may be incurred by the person who's looking after the estate. On the one hand, it would be easier if the deceased, the person who made the will, would also point out the fact that he wants that person to be compensated. However, it is a common situation that has been applied by the court, that estate trustees are entitled to compensation. And the idea is that, generally speaking, they're talking about between 4 and 6% of value of assets coming in and going out. In a more detailed fashion, there's a whole formula that we apply in order to calculate a estate trustee compensation. But there's no doubt that there are estates that require so much time and efforts that they can occupy a person's time almost as a part-time job or a full-time job, depending on the size of the estate and what needed to be done in order to maintain assets and management of assets, including bank accounts, investments, and so on. So the idea of compensating an estate trustee is there. It's very common, and sometimes it's up to the trustee to decide whether he wants to waive that option. And I've seen situations when that happened. In other matters, they feel entitled, and they are entitled to that compensation for having putting all these efforts to the benefit of all the others. So in that sense, that's the idea of having a compensation for estate trustees when they do take on the task.
Yeah, Golan, just to add to what Golan was saying, again, it's very important to have that in the will, so that there is no question whether the deceased wanted the estate trustee to have to be remunerated or compensated for the services, because it is a lot of work. It involves payment to professionals like lawyers or accountants. So if it is clearly written in the will, that is better. And of course we suggest that, and in our wills we put that as a standard paragraph. However, when there is no such paragraph, there can be disputes between the beneficiaries and the state trustee whether the amount will be payable or not. And then there are situations where it has gone to court even, whether the state trustee has a right to do that, and how much will he be compensated for. So in order to avoid any sort of those type of situation, it's always better to have the paragraph inserted there. One of the things that I wanted to also mention here, which probably has not been discussed in this session, is that as an estate trustee, a person has to ensure that all the debtors are paid, all the taxes are paid, because once the amounts are distributed to the beneficiaries, and if there is a shortfall later on, and the government makes a claim or a debtor makes a claim, then the state trustee will be responsible, because he has already given the money to the beneficiaries, and it is very unlikely that the beneficiaries will give any money back. So sometimes what we advise is, before the entire amount is distributed, there can be a holdback amount, basically for tax purposes or other purposes, whatever the amount is, so that in case any claim arises later on, that can be paid from that amount, and then the remaining amount can be distributed between the beneficiaries as the deceased wanted. Yeah, Daniel.
Thank you, guys. We're going to now answer any questions that you have. If you've not sent us your questions yet, it's not too late. You can use the chat option on your screen and type in your questions and send them to me. Guys, the first question we have is, if there's no executor selected because the deceased did not have a will, who looks after the estate?
Yeah, so as I was mentioning, if there is no will and there is no state trustee mentioned, then the law takes precedence, which is the Estates Acts in Ontario. And then that law basically says that the person who is who's applying to be the state trustee, because in any event, if there are assets in terms of real property, which is like a house or any type of vehicle, then you have to probate the will, and so you have to file an application to the court basically. So the court certifies that that person is a state trustee. The person who is applying must be a resident in Ontario. A certificate will not be granted to a non-resident. And again, as I mentioned, the law specifically says in order of priority, who can apply first, who can apply second, who can apply third. So there's a long list of people. So as I said, the first person who can apply to be the state trustee is the married spouse or conjugal partner who lived with the deceased immediately before the death. Can be the children, can be grandchildren, and the list goes on. So that would be the situation if a person dies without a will. Now, there is another thing I want to add as well, because in situations where, say, deceased has passed away and then he or she just have like $10,000–15,000 in the bank. In that case, I have seen banks, they don't need to probate the will to be probated or the estate to be probated. So they actually give them the money from the account based on what the law says as to who would get the amount. So it depends on the circumstances. Yeah, Golan, you want to add something to that?
I think you generally covered it, so I'm not gonna go any further. Daniel, do we have anything else?
The next question we have is, if the deceased was originally from Portugal and said in his will that he wanted to be buried in Portugal, does the estate have to absorb all of the costs for arranging the transportation of the remains to Portugal and for the burial there? Or could the executor instead just decide to cremate the person?
Well, thank you for the question, Daniel. I think I can answer that. In general terms, when a funeral directions are, it's nice to follow the deceased instructions. It's nice to feel that you satisfied all the person's wishes, the way that they wanted things to be done after their death. But it's not always feasible. It's not always possible. And with respect to funeral arrangements specifically, um, the courts have been uh, found that it's not a binding situation on the trustees to follow it to the T. So what happens is in a situation where the state may suffer significantly from um, an expensive arrangement that would require the transport of a body to another state or another a continent in that sense, it may be a significant cost that it does not make sense in the whole scheme of the size of the estates, etc. So, so the short answer is no. There is no a binding situation on the estate trustee to absorb the cost and go ahead with the instructions as set out. But it would be obviously a preference if the money is there and if the estate size allows that to happen, then I don't see why an executor would not want to follow the deceased instructions. But like I said, if the circumstances and the size of the estate is not sufficient, then there's no need for that to occur, and a more modest arrangement can be made with respect to the funeral arrangement, a cremation, etc.
Yeah, just to add to what Golan was saying, I had this experience in a situation where a person, when he made the will, he had a lot of money, to be very honest. And in his will, he said that, I want my ashes to be, my estate trustees to go on top of Alps and my ashes to be, scattered from there. But when he died, actually, he did not have that much money for the estate trustees to actually, go there and, do all these things. So as Golan was saying, it all depends on the circumstances and whether it's feasible or not. So yeah, so state trustees have that authority to determine what is best in that situation.
The next question we have is, can the deceased choose someone as the executor without that person's permission? And what if they don't want the job? What if they don't want the responsibilities?
Okay, so thank you for that question, if I can take that. So in order to name somebody in a will, you don't need anyone else's permission. The question, of course, arises that if the deceased or the person passes away, and then whether that person who has been named in the will wants to do that job or not, wants to perform the act of a state trustee or not. So if that person does not want to perform that role of a state trustee, nobody can force him. The law does not allow somebody to be forced against his or her wishes to be a state trustee. In that case, the option is, they can say, I don't want to be a state trustee. I want to renounce my role as a state trustee, and then somebody else can be, can take that role. So in that case, unless there's a agreement between the parties or the beneficiaries as well as the other state trustee, if there is two estate trustees, um, an application may be made in court, and then the court will grant a certificate saying that, okay, there has to be an explanation for us to be made to the court as to why this new person is actually substituting the other person. So there has to be this form, which is the renouncement application, renouncement form, which needs to be filled up by that person who does not want to play that role. And then the court will consider the circumstances and then can decide whether the person who is applying should be replaced in his place. So yeah, so basically the short answer is no, you cannot force somebody to be a state trustee, but there is no requirement to seek permission of a person to name somebody in the will.
If I may just add to Syed's, I would just say that that's the reason that we sometimes, actually always, suggest to people to consider when they appoint a state trustee, to also consider a substitution. There could be many reasons why one cannot act as a state trustee. It may be incapacitated by the time the grantor, the person who gave him the appointment and made the will, passed away. So there could be many reasons that one cannot act as a state trustee, and it's always a good to have a secondary option alternative if that event in fact happens. So it could be for the same reason that I just mentioned, that a person does not wish to be, but the situation might have been that at first he wanted to be and then he changed his mind, and so that situation may arise, and therefore always bear in mind that substitution or even a joint trustee that can take the act of doing the administration, it's always a nice thing to have thought about that scenario ahead of time. It's all about trying to predict some scenarios, and how they're going to unfold after one's death, that we're trying to cover in the will, and that's the reason that we definitely recommend that there would be a substitution appointment in case that happens.
Yeah, I just want to add to what Golan was saying, Daniel, and this is very important. So I have seen a lot of wills where people have named people as estate trustees in their wills who do not actually reside in Canada. So I know in Canada we have a lot of immigrants coming here. They don't have relatives, they don't have anybody who can be trusted. So they name in wills people who are actually not residing in Canada. They would probably need a visa to come here, and that becomes an issue because even if they want to be acting as their state trustee, without coming here, without actually physically being here, it is very difficult for them because they probably have to hire a lawyer from abroad. A lot of things need physical participation because you have to go to different places. So it is always better and suggested that we always suggest to our clients that you should have an estate trustee who's actually residing in Canada.
The next question we have is, if someone left the estate to their two sons and made both sons executors, how can you resolve a situations where the sons don't agree on what to do and what needs to be done?
I can answer that question, side. Um, so what the fact situation that I understand is that you have a joint executors who are also the only beneficiaries of the estate, and they might have an issue as to how to determine a distribution or something similar to that in terms of the administration of the estate. Um, Obviously, it may happen. It happened before. The best way to resolve disputes of that sort is to uh, mediate and try to resolve it as amicably as possible before the expenses get out of hand in terms of representation and court application, etc. So the first option that I would say is there's always the option of going to a mediator, uh, whether it's a lawyer or a professional mediator, to try and assist the executors, which are also the beneficiaries, to resolve that issue. So that is one of the options that are available. And if things do not work out, there's always the option of going to court and applying for direction by way of a motion and other procedures that can be taken in order to resolve the dispute. Obviously, going to court is the more expensive route, and we definitely find that going through the process of mediation is the way to go, and we have resolved many a situation of that sort just by mediating uh, for the estate trustees, or for even if the dispute may arise between the trustee and the beneficiaries, which also may happen. So there could be many situations that give rise to disputes while the estate is being administered, and that's the reason that we are a very pro mediation to preserve the relationship if it still exists, but try to minimize the consequence to the estate in terms of its size and in terms of any personal relationship that still remained. That's my comment on that question.
Yeah, I would just echo with what Golan is saying, basically, that mediation is the least expensive and fastest solution. I have seen people going to court because of, their ego or whatever, they cannot deal with the other person. And then what happens is at the end of the day, you pay the lawyers, you pay the court expenses and everything. And whatever is left on the state is coming from, it's depleting basically. So at the end of the day, they will share less from that total assets that is being depleted by going to court. So mediation is of course the best option if possible. But again, mediation is a voluntary process. The mediator does not have a right to tell them, you have to do this, you have to do that. He or she can only facilitate an agreement between the parties. And if they cannot come to a resolution, then of course they have to go to court and resolve it, which is of course the least desired option. But to resolve it, people sometimes have to go there.
The next question we have is, if someone is selected as an executor, but they've never been one before, how can they figure out what they should do?
Yes, that's a question that all the state trustees have when they have never performed this job before. And, as I said before, and Golan was mentioning as well, that they need to seek professional advice because they are in a trusted position. The person who died has named them as a state trustee so that they perform the services to the best of their ability. And to be very honest, if they are actually receiving compensation or remunerated for their services, then they're expected to be of that level because they are being paid for their services. So it has to be ensured that they perform the services to that level or to the highest possible standard. And they have to seek professional opinion, professional advice. They can seek opinion from lawyers, they can seek opinion from accountants. Um, and that is why we actually are there to guide state trustees, because we deal with it on a daily basis. So we tell them what to do, what are the documents that needs to be collected, what are the functions that need to be performed by a state trustee. And in the process, step by step, we help them out in the entire performance of their trusteeship. And then finally, they file the tax return with the Canada Revenue Agency if a return is required to be filed. And when they receive the document, which is called as a clearance certificate from the CRA, then they are actually can be said that okay, they have done the duties. However, one of the things that I always tell my clients that when you distribute the assets to the beneficiaries, you must ensure as a state trustee that you get a full and final release, which is a document which says that the beneficiaries has received the documents, they are satisfied with all the accounting and everything, so that there is no liability attached later on by a beneficiary or somebody does not claim later on that okay, the state trustees did not perform their role as they were supposed to do. Because I have seen situations where it was brothers and sisters, and they have distributed, they had very good relationships, but after 2 years, before the limitation period is over, a claim is filed that my brother or my sister did not perform their role accordingly. So the release document is very important. Gulan, do you want to add anything to that?
No, it sums it up. Do we have any more questions? Because I think we're running out of time here.
We do have one more question. It says that if the will says that all 3 children are to receive the estate equally, but only 2 are named as executors, does that mean they get to keep more, or they get to decide who gets how much?
I can answer that if I may. The short answer is no, they're not getting more than the rest of the beneficiaries if it is indicated in the will that the estate is to be shared equally. But equally means that it's the residue that's being distributed equally between amongst the beneficiaries, and the estate trustees. The only way that they may look like they're receiving more is because of the compensation that they may be entitled to as a state trustee. So other than that remuneration or the compensation that they receive for all the work that they had to do in collecting the assets and distributing, other than that, once there is a determination of the size of the estate and what's available for distribution, then the estate is being distributed equally, minus the compensation, of course, that the only two trustees would be sharing in. So other than that, there's no, just because there are two trustees and more beneficiaries, it doesn't mean that the trustees are entitled to any a larger a share in the estate, um, other than the, like I said, the issue of the compensation that may be added on to their share. Daniel, aside, if you have anything else.
No, I think you covered it all, but as we were talking before, we were mentioning before that if the state trustees take more than their share, then the beneficiaries will be asking for a passing of account. So that requires a detailed accounting, and the court can, they can apply to the court. So they would not want to be in that situation. They would rather, take according to the wishes of the deceased. So no, as Golan was saying, you cannot get more. You can just be compensated for your services.
And the last question we have, guys, is if there are 3 children, but the last remaining parent left everything to 2 children and basically gave nothing to the other child, can the child who got nothing complain?
Yes, if I can answer that question. So basically what I understand is you have 3 children, and then 2 of the children actually have been given the property or assets, and the 1 children is left out. Now, what is important in this situation is to be ascertained, to ascertain actually whether the will was done by the uh, deceased in his or her own free will without any undue influence, whether he or she had capacity at the time of making that will. If that is a situation where clients come to us and they say that, okay, this is a situation, I am living with this person and I want to give everything to him or her, he has been taking care of me or something like that, we actually ensure that, this is what they're doing of their own free will. There has been no influence by any of any sort on them, so that there is no question after the deceased passes away about challenging the will, or whether she was unduly influenced or not. So the other thing that we also want to mention is that when you have a situation where you do not want to give somebody a certain sum of money, you should mention that in the will, that as to why you are not giving it. Because if you don't mention it any reason, it might say that, okay, it was an oversight, or, the deceased probably was not of sound mind or something like that. And it can create problems later on. So in terms of the person who has been deprived or who has not gotten the share, he or she can, of course, challenge the will in a court of law. First of all, as Golan was saying, mediation is probably the first option that should be sought in terms of, or negotiation with the lawyers, or if there are brothers and sisters involved, talking to them and see whether that can be mutually resolved between all of them, 3 of them. If not, then, this person can, of course, challenge on various grounds a will. But most of the situations that we see where wills are challenged are undue influence, or incapacity, or the deceased did not understand what he was signing at the time. It's a lot of questions that arise from that particular situation is who took the deceased to the lawyer's office, who was residing, who was managing the deceased properties or assets at that time. So all these questions are very relevant, because at the end of the day, even if you allege undue influence, you have to prove it in a court of law if the matter goes to court, and it is not easy. The burden is quite high. So all these facts and circumstances needs to be, examined by a court.
Golan, do you like to
Yeah,
add anything?
I think from my experience, I noticed, I can tell you that whenever siblings are not getting an equal share, it raises an issue. Um, the question was whether they can complain. Well, everybody can complain for anything all the time. The question is whether they have, whether there is merits to the complaint and there's something that can be done about it. Sometimes it can be done, and other times the situation is so clear that the testator intended that end result, meaning that one of the children will not receive as much as the others for various reasons. It could be because that person or one of the siblings had received during his lifetime. It could be because, um, I saw situations where the parents were looking after the financial well-being of a, a less fortunate siblings who did not do well financially, at least in life, and others were independent. So there are reasons that sometimes are very justified in or reasonable in terms of how an estate is to be distributed. But even if it is not reasonable, as long as it is ascertainable, like Syed said, that one can actually determine that that was the wishes of the deceased, and it's clear on the record that, and the explanation is there, which is even better, then it is enforceable. That means that that person will receive less than the others if the will is found to be valid and enforceable, and that there were no other grounds that would vitiate that um, a capacity or the willingness of that testator, the person who left the estate to his siblings or others. So as long as those grounds cannot be made, that will stand. But it really is important to uh, have it grounded and supported by the notes and records that a professional will take uh, when the uh, when the instructions are given to the lawyer to prepare the will. So obviously, it may not be the ideal situation, but it arises from time to time.
Yeah, just to add to Golan, what Golan was saying is, as I said, the burden is very high, even if you want to challenge your will. And if you go to court and if you cannot actually prove your case and you lose, the cost consequences are very significant. So before a person embarks on that avenue or that process, he or she must ensure that, they have a good case, there enough evidence to suggest that, the will was not made voluntarily by the deceased, because the cost consequences can be very high.
Thank you guys for that. Those are all the questions that we have. If you have any more questions, a consultation can be arranged to evaluate your specific situation or circumstances. You can always contact us using the information that's on the screen now. As mentioned earlier, this was just a general information session and nothing mentioned should be taken as legal advice. That concludes our session. I want to thank Golan and Syed, and thanks everyone for attending, and hope you're able to join us next time.
Thank you, Daniel. Thank you, Syed. And thanks everyone for joining us this afternoon.
Yeah, thank you, Golan. Thank you, Daniel.